Good morning, everybody. Thank you very much for joining us today. My name is Lisa Smith, and I'm Senior Research Fellow in Business and Human Rights at BICL. Today is episode 3 of our webinar series on human rights due diligence for climate change impacts. And today's episode looks at mandatory human rights due diligence laws. What are the implications regarding corporate climate change impacts? Our experts will consider the legal implications of some new and proposed mandatory human rights due diligence laws and focus on how the respective legal standards would apply to companies in terms of undertaking climate change due diligence. Thank you very much for all our expert speakers for being willing to share your insights today. And I will start by introducing a speaker who really needs no introduction. Surya Deva is an associate professor at the School of Law of City University of Hong Kong and a member of the UN Working Group on Business and Human Rights. He has published extensively in the areas of business and human rights, India-China constitutional law and sustainable development, including as one of the founding editors-in-chief of the Business and Human Rights Journal. And he has advised UN bodies, governments, multinational corporations, and civil society organizations on matters related to. Thank you so much for joining us today, Surya. The floor is yours.
Thank you. Thank you, Lisa, for the kind invitation. And it's really a great pleasure to be joining this webinar with a very distinguished panel of experts. So in this brief time, I would like to focus on 3 aspects. First, I would like to highlight some interlinkages between climate change and human rights. And because of these interlinkages, there are relevant considerations to human rights due diligence, the whole series that we're talking about. Then I will talk about what needs to be done by whom, and I will base it on the 3 pillars of the UN guiding principles, because I'm drafting an information note about climate change and UN guiding principles, so that will also give you some idea where this climate change information note will be going. And finally, I will talk about some red flags or signposts that we should be careful about going forward. So let me start with interlinkages, and I would mention 4 elements that are crucial. The first is that I think it is very well established now that all businesses have a responsibility to respect human rights. Now, this responsibility to respect human rights cannot be discharged by any business unless they take into account climate change considerations throughout their process of due diligence. That is the first point. I think it hardly needs any elaboration, because whether these are civil and political rights or socioeconomic rights or cultural rights, all these rights are very closely connected with positive or adverse impact on the climate. So that is the first point. The second point is that we also have this right to development as a human right. Now, development can never be sustainable if we are not able to integrate climate considerations. And I'm trying to highlight this element because there is this temptation in many governments, especially in the global south, which are lagging behind in this so-called economic development, that they would consider that, okay, the global north has already developed and they ignored climate change considerations in that pathway of development, and now it's our turn to do the same. And that's why they tend to put issues about climate and environment on the back burner. And in my view, this is a problematic approach. And I think this integration should take place at the outset. And the whole idea of development will not be sustainable and equitable and inclusive if the climate considerations are not integrated at the outset and throughout this process. My third point is that this idea of adaptation and transition to low carbon economy must also be compatible with human rights. Because if it is not compatible with human rights, it is very likely that some people will suffer more of this transition. And I think if we ignore that, then we are not going to achieve sustainable development goals, which are based on the idea of leaving no one behind. So the idea of transition to low carbon economy should not mean leaving certain people behind. And that is inevitable if we do not integrate human rights considerations into adaptation and the transition approaches and the strategies. My fourth point is that often we talk about policy coherence in relation to governments, states. But I would like to highlight coherence also in relation to businesses. So if businesses make a commitment to respect human rights, but same company is lobbying against government regulations which are trying to reduce or cut down fossil fuel, there is incoherence here. So if you are funding certain things which are totally inconsistent with the idea of sustainability or climate mitigation, and at the same time, the same company is saying that we are respecting human rights, there is this contradiction. And I think this is something which is worth highlighting. Now let me move on to the second component of my presentation, and which is about who needs to do what. And as I mentioned to you briefly that I'm writing an information note for the working group on this issue. And I will just provide a snapshot of some of the ideas that may be relevant, and I welcome your comments and feedback on those ideas. In relation to Pillar 1, which is the state duty to protect human rights, I think it is critical that the states lead by example. They have to lead by example. It has several components. We have public procurement, and I think that should be used to create incentives for businesses which are mitigating climate change already, which are going for low carbon economy, instead of giving preference merely based on which business has offered to provide certain products or services at the lowest price. So I think the climate consideration has to be integrated in public procurement. State-owned enterprises, they have to again lead by example in this particular process. At the same time, states have to ensure that the businesses take climate crisis seriously. And I think, in my view, mandatory human rights due diligence is just one component of it. But there could be other ideas in terms of incentives and wider disincentives that the government should create. And that will also include disclosure regulations, whether these are about stock exchanges or disclosure even about the products that you're buying in a supermarket. For instance, now you have calories listed on the products that when you go to the supermarket. Should products going forward also mention when you buy a pair of jeans, should it provide you data how many liters of water is consumed by preparing that pair of jeans? That kind of disclosure is also going to be quite relevant. So it's not merely about mandatory human rights due diligence in my view. The second pillar, as you know, of the UN Guiding Principles is about the business responsibility to respect human rights. And here, I think it is very obvious that climate change considerations must be integrated at all 4 stages of human rights due diligence. As you would note that UN Guiding Principles do not mention climate change anywhere, which is a bit of a surprise because they were not adopted in the 20th century. They were adopted in 2011. Same applies to OECD guidelines. They don't mention climate change anywhere, though there is a chapter on environment and they talk about gas emissions, reduction of greenhouse gas emissions, which is good. But I think we need to bolster and make it more explicit what needs to happen in terms of Pillar 2 if businesses claim they are complying with UN Guiding Principles and OECD guidelines on responsible business conduct. I think that is an issue which is very much clear. But I would also like to highlight that we should not see climate change as a black box, that everyone is affected and impacted in the same way. So if businesses do not appreciate that the climate change is going to impact people differently and in disproportionate manner, then we are not going to achieve climate justice. The impact on women, for instance, the impact on indigenous communities could be very, very different. The impact on people who are already developed and have a very decent life could be very different from a person in the global south who is just striving to earn livelihood, you know. So I think that differentiated and disproportionate impact has to be factored in. It's not just that all the rights holders are impacted in a similar way. The third pillar is in terms of remedies. I think we should appreciate that climate change remediation involves some unique challenges about attribution, about standing, about transnational dimensions. So it's not environmental pollution kind of remediation. It's not typical human rights remediation that we're talking about. So while remediation is absolutely vital, we have to understand that we have to develop some different types of strategies and different kind of remediation. And I would just mention that restorative justice idea could be very much relevant here. And the second component I would like to highlight is the global accountability mechanism. Because if you hold a company accountable operating in one jurisdiction, that may have implication in another jurisdiction operating miles and miles apart, thousands of miles apart. So I think these are some of the points that I hope the information note will clarify. Finally, and very quickly, let me mention a couple of red flags. My first point is that there is this obsession, I would say, with human rights due diligence and mandatory human rights due diligence now. So it's the darling in the business and human rights field now. We should not think that this is a panacea. It's going to fix all the challenges. In my view, there's a critical distinction we should be making about obligations of means and obligations of result. In some cases, in the field of climate change, businesses as well as states must have an obligation of result. Merely doing a process will not help. We want to see the outcome. And if you do not achieve that outcome, that process, whatever you did, is totally useless in my view. So I think that is the red flag that I would like to highlight, because we often do not see it in this way. We think due diligence, you do it, and if you are able to satisfy that you have taken reasonable steps, that may also operate as a defense. This is highly problematic pathway in my view. The second red flag for me is if we create due diligence, which is without pillar 3 remediation, this is also problematic. So if businesses are merely required either because of comply or explain model, or if there are sanctions about of not doing it well, but there are no remedies that the affected communities can seek, then this is not going to work. So I think remediation based on the violation of human rights is absolutely vital. And my last point is human rights due diligence may not be able to solve the fundamental tension or fundamental challenge that we are dealing with. And that is about the current model of economic development. We need significant and transformative changes in how we consume and what we eat. If let us say the smartphone companies keep on releasing 2 models of smartphone every day, and they keep on encouraging consumers to buy more and eat more and do everything more and travel more, we will never be able to achieve climate justice. So we need significant transformative changes in this model of development, and mandatory human rights due diligence, unfortunately, will not achieve it. Thank you very much.
Thank you so much, Surya, for that absolutely brilliant and rich presentation. It gives us a very, very good framework and to frame our thoughts going further. Our next speaker is Chiara Macchi, and she is a Marie Sklodowska-Curie researcher at Wageningen University and Research Law Group, and an associate member of the Essex Business Human Rights Project. As part of her ongoing research focusing on EU policies in the area of business and human rights, she has been exploring the integration of climate due diligence into the notion of human rights due diligence. She has conducted consultancies for governments, NGOs, companies, trade unions, and lawyers on business and human rights related issues. And she's also the co-chair of the Business and Human Rights Working Group of the Netherlands Network for Human Rights Research, and a member of the European Law Institute's project, Business and Human Rights, Access to Justice and Effective Remedy. Thank you so much for joining us today, Chiara. Please go ahead.
Thank you, Liz. Thank you to all the other panelists and to everyone who is attending this session. In my intervention, I will focus on what I refer to as climate due diligence. I will argue that it constitutes an inherent dimension of human rights due diligence, and I will look at what corporations might be required to do in practice to comply with this standard of conduct. Let me start by saying that the fact that the UN Guiding Principles do not expressly refer to environmental law or climate law among their legal foundations, that does not bar a holistic approach to human rights due diligence. Quite on the contrary, in my opinion, a holistic interpretation of the underlying standard of conduct is the only coherent approach to the corporate responsibility to respect, one that takes into consideration all relevant international norms. A holistic approach to human rights due diligence means recognizing that the climate targets adopted by the international community to prevent the human rights impacts of climate change are relevant to the definition of what constitutes reasonable conduct for corporations. Regardless of the wording that the new EU regulatory instrument might adopt, therefore, human rights due diligence must be read through the mutually reinforcing principles of international human rights law, environmental law, and climate law. But what does the concept of climate due diligence entail in practice for corporations? I will answer by resorting to the UN Guiding Principles articulation of human rights due diligence and applying it to the concept that I define as climate due diligence. Climate due diligence as a standard of conduct binds all companies. All companies are potentially contributing or at least linked to climate change. They must assess the risk, communicate the results of such assessment, and act upon those findings. As shown by the complaint filed with the Dutch NCP against ING Bank, it is a responsibility of the company to find ways to measure its own impacts, a task that is facilitated today by advancements in climate science and in the availability of climate data. Risk assessment should entail not only the company's own emissions, but also aspects such as the climate change-related vulnerabilities of communities, categories, individuals that might be further impacted by the company's operations. Climate due diligence also entails checking the company's business relationships, the supply chain, and exercising leverage when necessary. To make an example, a bank might be directly linked to high level of greenhouse gases emissions through companies in its own portfolio. As clarified by the OHCHR, direct linked and direct contribution to adverse impacts are placed on a continuum. Thus, if the bank fails over time to exercise its leverage over the investees responsible for high levels of emissions, it might eventually find itself in a position of contribution, which entails a responsibility of remediation. Now, obviously, the specific climate due diligence steps required of a specific company will vary with its size, sector, and with the context of its operations. However, in some cases, the only way for a company to discharge its responsibility to respect will be to end its relationship with an entity whose contribution to climate change could not be mitigated through leverage. In the example of the bank, this might require a divestment decision, for instance. But what about those companies whose core business is literally the production and marketization of fossil fuels? For the so-called carbon majors, risk mitigation arguably requires cutting their emissions to a level at least compatible with the Paris Agreement's mitigation targets. For these companies, the reasonable approach to climate due diligence, at least according to my own reading of the UNGPs, is to start diverting their investments away from fossil fuel projects and to collaborate with governments to accelerate the energy transition, the low carbon transition. This obviously entails a fundamental shift in their core business, and according to the UN Guiding Principles, such a process must be carried out duly taking into account its potential adverse human rights impacts. But in light of the severity and irremediable character of climate change-related human rights impacts, the only way for carbon majors to discharge their responsibility to respect, I believe, is to engage in such a shift as a matter of urgency and to cooperate in the remediation of the impacts that they have already contributed to. Let me also specify that personally, I do not believe that investing in environmental projects around the world through carbon offset schemes is enough to discharge a company's responsibility to respect. The UN Guiding Principles stress that it is not possible to offset a company's failure to address its own human rights impacts by adopting voluntary CSR initiatives. In the same way, there is no way, in my opinion, of working around the duty of big emitters, such as the carbon majors, to mitigate their own emissions, their own contribution to worsening global warming. Now, some elements of climate due diligence are emerging from the rapidly growing examples of climate change litigation and might be further clarified in the near future as some of these cases reach the decision stage. Existing lawsuits accuse companies of failing to perform adequate climate risk assessments, to honestly communicate the real climate impacts, to set concrete climate objectives, but also in the case of big emitters, these companies are accused of having historically contributed to global emissions in a quantifiable manner, which in turn entails a duty to remediate the human rights impacts deriving from global warming. While climate change litigation is evolving, what can be the role of mandatory human rights due diligence? While climate change litigation is evolving, what can be the role of mandatory human rights due diligence legislation in relation to the necessity to consolidate a definition of climate due diligence? I am of the opinion, and I'm interested to hear the other panelists' ideas on this, that human rights due diligence as a standard of care for corporations, together with its climate due diligence components, already exists. It derives from an already established normative framework that informs what a reasonable corporation should do. And it exists before and regardless of any regulatory developments that we might witness in the area of mandatory human rights due diligence legislation. The expected role of this kind of legislation, therefore, including of the announced EU-wide instrument, is not so much to create a standard of conduct ex novo. The standard already exists. Rather, the added value of such a EU-wide instrument could be to better clarify such standard and its climate due diligence dimension, providing additional regulatory guidance to businesses, and most importantly, to link breaches of that standard to an improved access to remedies for affected individuals and communities. And I'm really looking forward to hear what the other distinguished panelists have to say on this last point. Thank you very much for your attention.
Thank you very much, Chiara. That was a really, really helpful and clear overview. Our next speaker is Katia Martin-Genout. She is Senior Researcher of the French National Center for Scientific Research attached to the University of Paris 1 Pantheon-Sorbonne and Deputy Director of Scientific Affairs at the Research Mission on Law and Justice. Her research focuses on corporate responsibilities for human rights abuses, including the right to a healthy environment. She's a member of the French National Consultative Commission on Human Rights, where she leads a working group on business human rights, and a member of the French National Platform of Global Actions for Corporate Social Responsibility. Thank you so much for joining us, Katia. We look forward to your presentation.
Sorry. Good morning. First of all, I would like to thank the organizers for inviting me to join this panel and to congratulate them for this initiative. The mobilization of human rights standards, such as the UNGP, for the protection of the environment and to prevent climate change seems fundamental for me. This has been my approach for years, but completely by accident. My contribution of a researcher specialized in international human rights law and corporate responsibility. When I started working on the issue of corporate responsibility for human rights violations, I was confronted with environmental degradation in relation to human rights violations. The tools I had were from the international human rights protection system. And it was these tools that I have mobilized by extending them to environment and even climate issues. For example, For example, at the time of COP21, as part of a research project developed at the Collège de France, we drew up a number of legal proposals to strengthen the responsibilities of states and corporations. And a part of a broad research project in the legal tools that could be used to reinforce corporate social responsibility, CSR captured by law, we have highlighted the cross-cutting nature of some legal tools, including the concept of due diligence. I think my research approach is in the line with the approach of the organizers of this webinar, who want to avoid the fragmentation between the work on human rights due diligence and the work on the fight against climate change. To this end, it is important to remember the potential of all the United Nations Human Rights Treaty monitoring bodies. For example, the Committee on Economic, Social and Cultural Rights in 2016, in its concluding observations on France, it encouraged the country to adopt a law on the duty of vigilance. This law, which is now being used to fight against climate change. With Paul Mojol, we are two speakers to talk about the French model. I will focus on what I consider to be movement of hardening at the national level, the soft law principle of due diligence established in the UNGP. I will briefly talk to you about this process, a veritable legislative saga. Then, in prospective way, I will discuss the irradiation potential of this French model within other normative space, notably European and United Nations. Behind this movement is the question of normative porosities between soft and hard law, but also between national, regional, and global normative spaces. The recognition by French law of a duty of vigilance imposed on parent companies and ordering companies is emblematic of these internormativities. The development of the concept of concept of due diligence from the United Nations sphere to the French national sphere, which is certainly not linear, shows this process which is hardening soft law and finally hardening CSR. Even is the issue of business human rights has been taken into consideration by United Nations since the 70s, it has taken on a new dimension since the end of the 90s, when the issue returned to the United Nations agenda. A process was launched within the former subcommission on human rights for the adoption of a hard law text. And in parallel, I think we can even say in competition, we saw the adoption of the Global Compact, soft law. The failure of the draft binding text was followed by the appointment of John Ruggie and the adoption of the UNGP by the Human Rights Council. The previous speakers have already discussed the principle very well, their potential for the protection of human rights, and I agree with them. Continuing their remarks, I would like to share with you a brief analysis of the evolution of these principles in the ways in which the fundamental notion at the core of these principles, which is due diligence, has been developed. The notion of due diligence is irradiated at the international level. John Ruggie was a very good strategist. He has worked closely with a number of public and private bodies during the 6 years he has been developing his principles. The guidelines have achieved the status of an international standard within the OECD, within ILO, within the European Union or the Council of Europe. The proliferation of norms in the field of corporate responsibility leads us to think of a normative jungle. And this can be dangerous. A normative jungle, instead of reinforcing responsibilities, can, on the contrary, dilute them, unless all standards seem to converge. And I think that due diligence is a point of convergence in this normative jungle. It is in this context that France has succeeded in adoption a law on the duty of vigilance. The legislative process was launched in 2013 in the context of the commotion caused by Rana Plaza drama. In this context, the first national steps have been taken to implement UNGP in France. A first draft national plan was drawn and the government sought the opinion of the National Consultative Commission on Human Rights, which highlighted the inadequate consideration of the risks of human rights violations and recommended that the government establish a legal duty of due diligence. Also in 2013, the legislative process was launched with lasted 3 years and met several resistance. For its opponents, the law was going to sacrifice the French economy and expose its corporations to unfair competition. French constitutional, I will try to, French Constitutional Council abolished punitive damage, but left the possibility for any person with a justified interest in action to ask the judge to order the company to comply with the duty of care, if necessary, under penalty. I will not go into details because Paul Majol will talk to us about this law and its mobilization in French tribunals. While due diligence is well known and used in international and in national law, this concept has taken on a new dimension with the UNGP. For corporations, while this concept was also known and used in corporate governance to determine business risks, it has become, thanks to UNGP, a standard for measuring compliance with international obligations. It has also left a context of simple internal risk management within the company. The risks that need to be prevented are not longer only those caused to the corporation, but also the risks that a corporation creates for third parties in the exercise of its activities. It has thus become an instrument for internal and external risk management in the area of human rights, including the right of health and environment. This notion applied to corporal responsibility has a soft nature, UNGP, but becomes hard law at the national level. It's the example of France. But with the Human Rights Council draft treaty, couldn't this notion become hard law this time at the global level as well? The process of negotiation, a binding instrument at the international level is not easy. Since 2014, the process has been paved with difficulties. Strong resistance has emerged, including from the European Union. One of the arguments against the adoption of a treaty was that soft law and the application of the UNGP should be favored instead, as if the two processes were incompatible. However, the two processes are not incompatible and should not be considered as competitors. They are completely complementary. A binding text could be used in the event of a failure of a soft law and voluntary commitments in the areas of human rights, but also in the fight against climate change. How can we move from competition between these forms of normativity to complementarity? Position seems to be changing. Perhaps the health crisis of COVID was played and will play a role in this movement. At the European level, the impact of health crisis in the evolution of the position on the adoption of a binding text of the duty of vigilance seems obvious to me. The Rainer's declaration and acceleration of the timetable occurred during the peak of the health crisis in Europe. Debates on the fragility of supply chains contribute to spread this notion. The argument used by the opponents of the adoption of a national law on the duty of vigilance in France must be recalled. French companies should not be penalized. However, in order for them not to be sacrificed, this debate must be brought to the European level, and a binding text of a duty of vigilance adopt at this level. But the argument can be made again, this time with regard to European companies. They should not be penalized. In order not to be penalized, this debate must also be conducted at the global level, and the current negotiations in the United Nations Human Rights Council can contribute to a goal irradiation of due diligence this time around. Even if the process will be hard and a large part of responsibility still lies with the states, is this not a path eventually? In my opinion, yes, provided that the text does not imply a lowering of the level and that it does not fall short of the UNGP. Thank you for your attention.
Thank you so much, Katja, for that very, very helpful background and overview. Our next speaker will similarly continue the discussion about the French framework. Paul Mogel is project coordinator and legal advisor at Notre Affaires Atout, and as well as a PhD candidate at Paris Nanterre University and the University of Potsdam. Paul leads the work of the French climate litigation against Total, and he directed a comparative study on the implementation of the climate due diligence standards by 25 corporations. Thank you so much for joining us today, Paul.
Thank you very much for this introduction. Can you see my slides and can you hear me well? It's okay? Okay, good. So I'll try to keep it very short. I will give a presentation today about the existence and the extent of a climate standard of care in France. So as Lise already presented me, I'm working for the NGO Notre Affaires Atout, and we launched the first climate litigation in France, I guess, a business enterprise. It is Total. Total is an oil and gas company, which is it's a biggest company in France, one of the major contributor worldwide to greenhouse gases. Its greenhouse gases represent 1% of worldwide emissions. The problem was when the Duty of Vigilance Act was adopted in France, it is a very general law. It is only saying that human rights and environmental impacts must be prevented, but it does not specify more what should be done. So the first climate vigilance plan of Total was not addressing the climate issue. We started this litigation with addressing a letter of non-compliance to the company in 2018 to notify them that they have to integrate climate aspects and to prevent it. They responded just afterwards that they will change their second vigilance plan and they will address this issue, but they just took on their climate corporate social responsibility information that was already released by the company and integrated in the vigilance plan. So substantially, it didn't change anything. However, they agree now that this climate change is part of the law. So there is no dispute anymore regarding this matter. We're basing also our claims on the tort environmental duty of care, to which everyone is beholden in France. And the legal literature specified very clearly that that does also apply to climate change impacts. So this is important, I think, because we don't need mandatory human rights due diligence as in France to claim a climate standard of care, because it probably already exists in the tort law liability schemes. Other evidence is also coming from the corporate world. So 15 out of 25 large emitting companies coming from very high emitting sectors such as financial sector, energy sector, transportation, construction are already integrating the climate aspects in the vigilance plan. This was in the second vigilance plan, so last year. Maybe there will be even more this year. So these are some findings that you can find in the climate vigilance benchmark. There is a summary in English that is open access and available on the website of Notre Affaire. I think a climate standard of care is very useful because the regulatory framework which is in place for companies is very limited and it is not ambitious enough. Take, for instance, the European trading system. Companies must only surrender allowances against the emissions with regard to direct emissions stemming from their industrial activities. So in the case of Total, when they are extracting fossil fuels, for this part they have to surrender allowances, but not when they're selling products to their customers. The burning of the process of burning fossil fuels is releasing the major part of greenhouse gas emissions. So we have a whole part of greenhouse gases in Europe that are not addressed directly by the framework. And the climate standard of care, I think, enables us to seek responsibility of companies for their direct, but also for their indirect emission, as long as their contribution to global warming, to the harm, is foreseeable. Total is denying this responsibility. I addressed this issue in the last issue of the Carbon and Climate Law Review that was published in the summer. But very briefly, I will give some elements why they should also reduce their indirect Scope 3 emission. Other companies such as BNP, Airbus, PSA, Peugeot Citroën, Michelin are also already doing it. Even ING in the Netherlands stated they are trying to reduce their financial emissions, their emissions related to their financial activities. So these are also indirect Scope 3 emissions. They are often stating companies that they're doing it on a voluntary basis. But however, I don't think this is the case. The standard of care is actually already requiring this. It is a legitimate expectation. It is also stated very clearly in some soft law text. And even the principles on climate obligations of enterprises that were drafted by very recognized jurists from all over the world already set out very clear obligations from parent companies with regard to their subsidiaries, to their supply chain, but also to their products and services. So there's a whole range of obligations that already apply, I think, especially through the standard of care to companies. We drafted some recommendations in our climate vigilance benchmark study, and we sent it to all the companies through a letter. And these are also claims against Total in the litigation. So companies must do that in order to prevent non-compliance risks with the statute of vigilance, for instance. So first of all, they have to track direct and indirect emission. They have to recognize that they have a share of responsibility. They have to identify climate-related risks with regards to human rights, to the environment in general. And then if they assess properly science, they will be able to know that in order to limit global warming, dangerous global warming, they have to limit global warming to 1.5 degrees. This is a global target that is also enshrined in the Paris Agreement. And in order to do that, they have to also implement coherent, so consistent measures and effective measures to reduce their greenhouse gases to zero by 2050. All these steps must be reported, especially in the vigilance plan. And if this is still not enough to tackle climate change on a global scale, I think they should call on governments to enhance the regulatory framework, especially if the companies are not able to self-regulate. Some words with regards climate, loss and damage, and adaptation. So everything which is not concerning the reduction of greenhouse gases and climate mitigation. When businesses are transitioning to zero emissions, they should as Surya already told us, ensures that they are protecting and considering the rights of their workers and the affected stakeholders by this transition. And with regard to the harms that are already taking place today, and there will be even more, some litigation are trying to receive compensation, especially from fossil fuel companies in the US. These are claims made by very large municipalities such as New York, Auckland. Even though I support the spirit of this claim, there is an evident risk that many victims, because the list is potentially infinite, will remain uncompensated. So you open the floodgates and there will not be any sufficient compensation for everyone. So this is, I think, a risk that must be taken into account. In any case, companies should cooperate on a global scale to find solution to that problem with the international community and other companies. And according to me, an extended responsibility scheme should be introduced, as it is already in place in Europe for waste, in the waste legislation, so that this problem can be solved on a global or at least European scale. So thank you very much. I will stop to share my screen.
Thank you so much, Paul, for such a brilliant overview of some of the concrete steps that are also included in the standard of care and various other points that you made. We turn our attention now to Germany and the German framework and discussions that have taken place there in this regard. Our next speaker is Lena Walker. She's a PhD student at the Institute for Environmental and Planning Law at the University of Münster. She currently explores environmental due diligence regulation in European and national law. Lena studied law in Münster, Germany, and Zaragoza, Spain, and completed her legal clerkship at the High Regional Court of Cologne. And at the German Federal Ministry for Economic Cooperation and Development in Cape Town, South Africa. She has worked in environmental law at Kirk Lawyers and contributed to several expert reports on human rights due diligence, amongst others for Amnesty International. Thank you so much for joining us today, Lena, and please go ahead.
Thank you, Lisa, for the kind introduction. I'm going to talk to you today about the German preparatory work on a human rights and environmental due diligence law. So what I'm going to present is two documents that are part of these preparatory works. They are documents by the German government, or parts of the German government. And I'm going to focus on comparing these two documents in relation to climate change. The first one is, I'm going to call it the draft law. It was a classified document that was leaked to the public in February 2019. It's a document by the Federal Ministry for Cooperation and Development. So what does this draft law contain? It's applicable to businesses with more than 250 employees and an annual turnover of more than 40 million per year. What are the duties in this law? Among others, to conduct due diligence. This includes the whole supply chain, so including subsidiaries and contractors. The due diligence is a human rights due diligence, but also expressly an environmental due diligence. The law foresees a duty to appoint a compliance officer to monitor the compliance with the law's requirements. It also foresees the duty to establish a complaints mechanism, including whistleblower protection. The consequences of a breach of the duty of diligence are, among others, the intervention of public authorities, criminal sanctions, exclusion from public procurement, and the law also makes reference to civil liability, to general civil liability, without further clarifying. One major challenge in relation to environmental issues, such as climate change, is to find an appropriate material standard or substantive standard. And the solution of the draft is that it refers to basic requirements of environmental protection. And this is further clarified by 3 points. The national laws of the host state concerning air, water, soil, the climate, biodiversity, and preservation of natural resources. Second, multinational environmental agreements which are binding for Germany. And third, the international best available technology. So what would the consequences of this duty be for climate change impacts? What would the proposed law require businesses to do? First of all, it would require them to do due diligence, to do a risk assessment. So if the business is prone to affect the climate, for example, by using fossil fuels, the business would have to identify and mitigate this risk. But to what extent? The question which emissions would still be acceptable and which would surpass the limit to a violation of this duty is left open. So in my opinion, the draft does not find a satisfying solution to this question. So maybe you thought this draft law sounded at least quite promising. Now I have to disappoint you that there has been a new document that was officially published by two ministries, the Ministry of Labor and the Ministry of Development. It was published in March 2020. It's called the Draft Key Points of a Federal Law on Strengthening Corporate Due Diligence to Prevent Human Rights Violations in Global Value Chains, or in short, the Due Diligence Act. So what does this contain in comparison to the first draft law? It is restricted in several aspects. First of all, it's only applicable to companies with more than 500 employees. That's in total a number of about 7,280 companies in Germany. Also, the due diligence obligation is restricted. In this draft, the human rights due diligence is in focus, so it's a human rights focused approach, and there is no general environmental due diligence. Instead, this draft makes reference to certain areas of risk, which are damage to health, to accommodation, or the economic goods needed for subsistence. For example, water, soil, or air pollution. So the climate is not mentioned anymore. This proposal also contains civil liability, but it is also restricted in this respect. It names only certain violations. For example, the harm to life, to health, freedom, property, and the right to privacy. The document also clarifies that the duty is an obligation only to make an effort, that the burden of proof lays on the claimant, and it includes a safe harbor clause. That is, that companies that implemented an approved industry standard can limit their liability to intent and gross negligence. So climate change in this proposal plays a minor role. Claimants in litigation will have to rely on human rights violations by environmental damages. So this leaves them with additional challenges, for example, to demonstrate the company's contribution to climate change and causality, etc. So what can we expect from a future German law? In my opinion, it seems clear that the German government, the current government, has agreed internally that there will be some kind of due diligence act. However, it is unclear to which companies it will be applicable. In a recent statement, the Federal Minister of Economic Affairs, Altmaier, argued that the law should be applicable only to companies that employ at least 5,000 people. Also, under the current government, it is rather unlikely that the law will contain a civil liability clause. Mr. Altmaier also mentioned that he is not in favor of this civil liability. I also am of the opinion that it will not, most probably not contain duties that specifically refer to climate change. However, there will be elections in Germany next year in September, so in 1 year. And my predictions are, of course, only true if the law is passed before these elections. Thank you so much for your attention. I'm happy to discuss.
Thank you so much, Lena. That was a really, really helpful overview of the development in Germany. Our next speaker will continue to speak from the practical perspective about the German perspective. Roda Verheyen is partner at the firm Rechtsanwälte Günther and specializes in environmental planning and energy law. Roda's PhD focused on climate change damage in international law, and she's the co-author of one of the main textbooks on environmental law in Germany. She was a co-founder and director of the Climate Justice Program and has advised as consultant many organizations, including the German Federal Environment Ministry and multiple civil society organizations. Active cases include the matter of Luya versus RWE, several cases relating to consents for coal power plants in Germany and Poland, an ongoing dispute before the German Constitutional Court relating to climate protection, as well as the People's Climate case brought by families inside and outside of the EU. Thank you so much for joining us today, Roda. Please go ahead.
Yes, hello everyone. Thank you for having me. Thank you for the seminar. I haven't prepared any slides because I wasn't aware which kinds of information Lena was going to provide. So now I'm just going to provide some points that I'd like to add to what was already said. I think in this whole debate, we have to really differentiate between the issue of due diligence or due diligence national laws or EU law and the matter of substantive legal duties on companies. That is a real necessity, and I entirely agree with what Chiara said, that these duties already exist, as can be seen in the Shell case in the Netherlands. However, we're not there yet. We haven't actually received one single proper judgment in any jurisdiction. So we need to really make and develop the point of what are these tort or nuisance type rules, what's the standard that is applicable there. There needs to be a lot more research done. That's not my task primarily. I try to apply what you guys do, if possible. So there is a huge gap for us to actually apply these standards. However, I think what was phrased before, the remediation issue of how do we actually kind of link human rights and climate cases together. My case, Saul, so the RWE case, the Peruvian house owner, actually does sort of this thing. While it is not a human rights case, it actually addresses remediation. It's, I think, worldwide the first one that actually does this in a concrete way and actually reached evidence phase. We've got, yet to wait what results from this case, but this would, to some extent, be the first case where a specific human rights infringement equals a nuisance infringement under national tort law, and where we can actually find remedies, concrete remedies. What I would like to draw attention to as well is that these kinds of cases obviously also turn on what is due diligence for companies, because you can either talk about due diligence with respect to general obligations toward the public or the globe or something, or you could actually turn to what is mostly referred to directors' duties with respect to the company. And there's a lot of development in terms of disclosure and, directors' duties and things like that. So I believe that if there is a substantive duty to actually take climate change into account, both with respect to physical risk and regulatory risk and litigation risk, that actually then will translate and does translate already into disclosure rules and thus substantive law. Again, we're not there yet. The kinds of cases that we're talking about here with respect to material duties and actual remedies, so do you actually ever get a judgment, right, against that company? This issue has not reached accountant firms. There is no substantive materiality standard that has actually ever been reached yet. So we see CSR type reporting, but the task, I think, also for academia now is to actually turn that over into materiality financial reporting. That's where we're at. And I think we're really at the threshold. In my mind, these duties exist already. The issue is how to capture them. What I think should be stated with respect to national laws and the types of cases that Paul was referring to in France, and also with respect to our initiative in Germany right now, is that we're not there yet either. Because if you look at the general perception and what economists tend to say about these kinds of initiatives, it's mostly completely negative. There is no perception in the public, and that's not with the judges, that's very important to my mind, that we actually need these kinds of laws, that there is a need to recapture globalization in this way. And there's a huge issue of how to actually substantiate these kinds of duties. So that's why the Rana Plaza case in Germany failed. It only, I mean, legally it failed because of other issues, yeah, that are vested in Pakistani law or Bangladeshi law for the other case. But it actually failed substantively because there was such huge reluctance to actually establish standards that are not set out in law. So I really believe the issue here for us, for all of us, is to actually work hard on substantiating the laws. And Paul's publication on benchmarks actually does this to some extent. The Shell case does it to some extent with concrete medium term targets and the greenhouse gas reduction target overall. I would like to note that in the German debate, what we're currently seeing is, both from lawyers, professors, and economists, the types of arguments as follows. These kinds of laws will not help, but actually cause the opposite effect in the host countries, because children that are no longer able to work in factories where German, corporations ask them to not be employed, will then essentially go into prostitution. Those kinds of arguments are seriously in the German media currently. So there is a very steep a steep hurdle to be overcome still, and I think that will happen with the EU law as well. So we need to really get the message out there. What is due diligence? What does it mean? Why do we need it? And that it actually helps people to understand how this is not an impossible burden on companies. That's the other thing. Then I would like to talk a little bit about what is the substantive duty of due diligence, because I think that's really important, what Paul said about the benchmarks and how to actually make it workable. There's huge differences between types of industries, I think. And Paul's report is the first that actually looks at these different areas and how to make it work. Because to be honest, what we've done so far is only looked at the carbon majors. We've really only looked at either the main producers of emissions, so my RWE case or the Exxon cases, or no, actually not the Exxon case. The Exxon case is like the Total case, so it's about the product. It's a global chain of oil or gas production where you can actually very well capture through extraction the part of whatever percentage of global emission responsibility. What we haven't done at all is to actually look at real supply chain issues and companies. And that's another point for research in my view. I'm working on a project currently with an electronics and metal production, medium-sized company here in Germany on how to actually make that work in due diligence. What can one company that produces not emissions, not oil, not gas, the products are completely, I don't know, all over the place, right? Then how do you do that? What can you do? And that's something that nobody has worked on properly. So I would really call on the global research community to do that, because that will be needed if we actually want support for these kinds of substantive laws, which I think we all agree we will need to make this work. Even if the standards already exist, people like me who sit here in legal offices and try to actually get judges to declare something will probably need a little more. I mean, let's see what happens. The last issue, and that's, I think, something that needs to go to the company law directorates of whichever institution people are working for, is work on the whole issue of the separation principle. I mean, due diligence, what does that actually mean? It means that you are, to some degree at least, responsible for what others do along the supply chain. And even if you don't actually break the principle of responsibility for your own legal company or own legal entity, that's what it essentially is about. It makes you responsible for what other people do. And this is something that actually is vested theoretically and in legal terms, to my mind, in the concept of why legal entities are shielded in this way through company law. And because the environmental sphere, and I mean, let's not even talk about climate activists or climate lawyers, they're completely shielded to some extent from company law. This issue of business, human rights, environment, and due diligence actually makes or breaks these boundaries a little bit, which is why I find this very helpful. But essentially what we need to talk about more is about the issue of why do we actually need this shielding principle? What is the real reason behind it, and do we actually still need it with respect to, you know, you can take whatever international global covenant, you know, the UN guiding principles or any other, do we actually still need it? Is it actually sustainable? And that goes back to what we heard before in the beginning from Surya. So I don't know where I am about time, but I think I'll stop here and yeah, just keep on the good work.
Thank you so much, Hoda. That really resonated, I think, for all of us a lot with our work and what we're trying to also achieve with looking forward with this webinar series, this call for further legal research and analysis and clarification. So thank you very much for that food for thought. So our next speaker is Meryl Laurier-White, a member of the Debevoise and Plimpton International Dispute Resolution Group based in London. Meryl's practice includes contentious and advisory work across public international law, investment treaty arbitration, commercial arbitration, international humanitarian law, human rights, and transitional justice. Meryl is also a member of the firm's Business Integrity Group, assisting clients to understand and mitigate the business and human rights and environmental impacts. She's also a member of the IBA's subcommittee on ESG and arbitration and on the Justice Rapid Response roster of experts for the investigation and reporting on international humanitarian law, human rights, and criminal law violations. Meryl, thank you so much for joining us today. We look forward to your presentation.
Thank you very much, Lise, for the kind introduction and for the invitation to join the panel. It's a real pleasure to be here today and to learn from all the other panelists as well. Excuse me. So, as you've already heard, today we've been asked to think about the factors that might influence the standards in considering climate change impacts in the context of mandatory human rights due diligence law, and particularly the law proposed by the EU, and also to consider remedies. So it's a little bit of gazing into the future and considering the various factors that may and should be taken into account. You've also heard from the other panelists about various frameworks that might shed some light on this, the UNGPs, national laws, and my objective is to add just a couple of other framework considerations into the mix of today's discussion. The first of those is the primary public international law instrument applicable to climate change, the Paris Agreement. As many of you will know, the Paris Agreement enshrines the objective to hold global average temperature to well below 2 degrees pre-industrial levels with an aspirational goal of 1.5 degrees. Amongst other things, states set nationally determined contributions, their climate goals, as it were, under the scope of the agreement. The EU's current NDC is to reduce greenhouse gas emissions by at least 40% by 2030 as compared to 1990. And everything we're talking about today has to be seen in the context of the fact that living up to the 40% goal will clearly require a rather large shift in regulation, policy, incentives, and how we do most things, including business. So we can expect that due diligence requirements as to environmental and climate change impacts will be moulded by the EU's commitments and the member states' national energy and climate plans. For example, we can expect that the emphasis the EU has placed on land use and change in land use to trickle into how businesses understand climate impacts in their operations and supply chains and what that means for the assessment of risks. The changing laws and regulations are already beginning to directly apply to businesses, and we should not understand the forthcoming due diligence legislation in isolation from the many other regulatory initiatives the EU is currently pushing through. The disclosure regulation, the taxonomy regulation, and the new conflicts minerals regulation, which requires due diligence, for example. Partly is because As a practical matter, most businesses are not going to set up separate processes to assess and report on risk for different regulations. They're going to integrate the requirements into the same process. A degree of diligence is necessary to report, for example, and many of the reporting regulations actually require that businesses report on the process itself. So the process itself becomes as much of the focus as the end product. And the definitions and thresholds that are therefore applied within one set of regulations will be relevant for how the others play out in practice. And the taxonomy used for one will mold the terms used and the risks conceived of for the purposes of another. So just as a small aside here, and because it hasn't really been discussed yet, another piece of legislation that will be relevant to understanding the standards that will be applied to due diligence of at least some corporations in the UK, we don't know how many yet, is the proposed legislation targeting use of products resulting from illegal deforestation. There isn't a huge amount of information about this legislation available. The consultation will finish on the 5th of October. But a couple of things we do know is that the law would make it illegal for larger businesses to use forest risk commodities that have not been produced in accordance with local laws protecting forests and other natural ecosystems. And it will mandate supply chain due diligence into these factors and publication of the results. And there are also proposals that it be extended to institutions financing deforestation indirectly. So given the link to the illegality standard, we can probably expect that the due diligence standard will be either relatively exacting or will be taken relatively seriously. Separate from the national and regional shifts in the regulatory framework, the Paris Agreement has already begun to influence the behaviour of businesses directly rather than via national legislation. So this is another example of public international law influencing the behaviour of private actors directly. Certain businesses have already committed to aligning with the Paris goals, for example, in the Katowice Declaration. And then before I leave the Paris Agreement, just one quick word on remedies. The dispute resolution provisions, which are obviously state-state, refer to ICJ adjudication or arbitration where there has been the requisite consent. Very few states have given this consent, so the default mechanism is conciliation. We don't know the exact contours of a conciliation mechanism yet, but state-state claims could be direct claims for non-compliance, and they could also conceivably involve diplomatic protection claims. Not only is this theoretically possible, but there's precedent for diplomatic protection claims in conciliation at the international level. There would be some real challenges to this route, given the nature of the Paris Agreement obligations and the procedural hurdles associated with diplomatic protection claims. We know that the outcome would be a recommendatory award, but we don't know what the process would be or the transparency involved, nor the international pressure associated with it, all of which would affect the type of remedy available. The second framework point I want to make is on the intersection between climate change and human rights, that they're legally integrated as a matter of public international law, but also practically integrated in many specific scenarios. Legally, they're part of an international system that prefers integration over conflict, so they'll be read together where possible. We can also see this intersection in the decisions of human rights courts and bodies, which could well add to the regulatory recalibration we've just discussed. And the Paris Agreement also emphasises the importance of respecting human rights in efforts to combat climate change, and Surya has mentioned why that's the case. They're also linked as a practical matter in terms of assessing risks and mitigating impacts. So my colleagues have already spoken about many points of overlap, but just 2 points I want to add to this. The Bickel report that was commissioned by the EC and fed into the announcement of the due diligence legislation found that many respondents conduct climate due diligence without actually calling it that, in a silo from human rights due diligence. Practically, that might misunderstand the risks and impacts and how they intersect. So if you think about scenarios such as the conflict in parts of South Sudan or displacement in the Sahel, which are influenced by both factors, if you address the risks associated with supply chains in isolation, it might skew what comes out at the end. It will also upset the application of principles that apply to allocate resources and focus as part of the due diligence process, such as proportionality, because proportionality depends on an assessment of severity, and if the various factors are not being fed into each other in the way they interact, the actual severity in practice might not be properly understood. There's just one point I want to pause on here that the legislation might want to consider in this respect, which is the limited data and modelling that's available in respect of some areas and industries that determines what can actually be done and understood in a due diligence process. This data and modelling can be particularly important in understanding specific effects of what are often in a climate change context seen as very diffuse impacts. And it's also important in understanding how to address and assess the intersection with more specific impacts caused by other risks. Another important point of integration is the mainstreaming of certain perspectives across all areas of due diligence, for example, adopting a gender lens. As Surya has already mentioned, a gender lens not only recognises that impacts might be better or worse based on gender, but also that risks and impacts might be experienced completely differently, and that avoiding them or remedying them might require different approaches. So it's an important part of not only effective human rights due diligence, but it also applies to climate change concerns, and factors such as this will and should influence the practice of due diligence under future laws. So in essence, these frameworks again emphasize the importance of an integrated and contextual approach to due diligence in theory and in practice when considering standard and implementation. Just one final note. The overarching goal of any due diligence legislation must be prevention and mitigation. Not that remedy is not important, it has huge value, especially normative value, but there's only so much that law and compliance can do once the damage has been done. And that's one of the key lessons we take away from these other frameworks, other arenas and contexts, that in the same way you can never truly remedy in the sense of reverse an experience of sexual violence, many climate impacts can equally not be reversed. And that's an important overarching objective of any due diligence standard. Thank you.
Thank you so much, Meryl, for those very important points and placing it within the international framework as well, and then again speaking to the need for further and in-depth research and analysis being required rather urgently. Thank you very much for that. So our final speaker today is Sarah Zek. She's an associate professor at the Shirley School of Law and Marine and Environmental Law Institute at Dalhousie University in Canada. In 2015, Sarah was the recipient of an Emerging Scholarship Award from the Academy of Environmental Law of the IUCN in recognition of her research contributions in sustainable mining and international environmental law. She is a co-editor of Global Environmental Change and Innovation in International Law, co-editor of a special issue of the Canadian Journal of Women in the Law on resource extraction and the human rights of women and girls, and co-editor of the forthcoming Cambridge Handbook on Environmental Justice and Sustainable Development. Current projects include co-editing a research handbook on international and transnational approaches to climate loss and damage. She is affiliated with the Business and Human Rights Scholars Association, the Business and Human Rights Teaching Forum, and the Global Network for Human Rights and the Environment. Sarah, thank you so much for joining us today, and we very much look forward to your contribution.
Thank you very much to the organizers and to all of my co-panelists. I've learned a great deal in this session and have the challenge of trying to pull some threads together. I want to start by acknowledging that I am speaking from the ancestral and unceded territory of the Mi'kmaq in Nova Scotia. I'm based in Halifax. One of the comments made by Surya was of the need for transformative change, and that even the best EU human rights due diligence legislation, even with lots of reference to climate impacts, is not going to be enough. And I think I'm going to start there. I absolutely endorse the sense, which was common among several panelists, that already there is an existing standard of human rights and climate due diligence, and so we do not need specifically legislation for this to exist. It's already there. But whether or not we have legislation or are interpreting what we understand as being already there is an interpretive exercise. And so I think we should reflect on what it means that unless there is specific reference, for example, to gender or to the rights of children, it is assumed that the human who is the subject of rights is not a woman, or is not a child, or is not an Indigenous person. The starting point of the human rights framework, an assumption that we make, and this is not just about who the human is who's the holder of rights, it's also how we think about the worker, it's also how we think about the investor, is as what I call a bounded autonomous individual. This is the liberal subject who pretends to exist autonomously without being dependent on relationships with other people or with nature. And this is a fundamentally problematic starting point for any work in the human rights space that I think we have to confront. The writings that I've done in this area have drawn upon feminist and relational theorists, but also Indigenous theorists. And so another important piece is recognition that, and this has also come up, that everyone is differentially situated. And so I would not say that everybody is the same. But why is it that the starting point is that unless we make specific additional reference to gender or to children or to Indigenous rights or to whatever, that we assume this is not included? So when we think about what is required for human rights due diligence, we should think, this is my claim, whatever the context is, we should always question what we are thinking about the human, and think of the human as what I call an ecologically embedded relational being, again, all differentially situated. I think that is a piece of the transformative change puzzle that we need to confront as human rights, those who are engaged in conversations about human rights. And I think this changes how we think about not just rights, but also responsibilities. Because a very important part, which we see in particular in many indigenous cultures, and I should note that I had the tremendous privilege of listening for 2 hours to Mi'kmaq elders and other knowledge holders talking about environmental responsibilities within the communities here. An important part of moving from the bounded autonomous individual of the liberal framework into thinking about the ecologically embedded relational human is that it means it draws our attention not just to rights, but also to responsibilities. And responsibilities of all humans, but this extends also when we think about workers and workers' rights, when we think about investors, when we think about those who are within the company, as opposed to, and when we think about how we think about companies. I'm still, I would say, at the somewhat early stages of trying to figure out what the implications are of transformative change if we take this step, but I do think this is important. And I have several publications which I can sort of share where I'm exploring these ideas. But that's the first point that I want to make. I think this is important. I think we need to think transformatively, and this is a piece of the puzzle. So I'm not sure how much time I have, maybe another couple of brief moments. Okay, good. I'm gonna have a few more minutes, great. So let me then add a few other, let me maybe give a couple of concrete examples of this. First of all, so I have suggested that, for example, if we think of the Rana Plaza example, and we focus on this tragic event through the lens of a worker, we miss perhaps other issues surrounding the factory context that might come into play if we were to think of the worker as this ecologically embedded relational being. So in one piece that I've written about on this, my claim would be that if you take that approach, then you bring in issues of environmental degradation that are also associated with these kinds of factories. And so the claim would be you need to think of the worker as not just a worker who is doing their supply chain work to keep the global economy functioning, but also as somebody who is a member of a family and a member of a community, and ecologically embedded within that community space, as well as somebody who is part of sort of a global planetary Mother Earth system. I'll leave that example there for the moment. Okay, let me just conclude with a couple of other reflections from things that people have said. One is actually the comment about limited liability and why it is that we have that. I think this was an important point, but I also think that we sometimes forget, and that the reason we do have this is to protect small business owners, perhaps, who in a time of COVID-19 crisis, many of them are going to be facing bankruptcy. So I think it's an important principle that's there, and there's a reason for it. And the question might be the extent to which it should, or to which we should overcome this principle in different contexts. But it did have a good reason, and has a good reason, and will be relied upon, unfortunately, by many companies that are facing a crisis due to our current pandemic situation. So I think there's more to talk about there, but it struck me that that was actually an important piece. Let me see where I am. Maybe I'm just going to finish there. I know we're close to the end of our time, and maybe that's all I'll say. But just to reiterate again, I think transformative change is going to require us to think differently. And so I offer those thoughts and look forward to further conversations on this. Thank you.
Thank you so much, Sarah. That was such a good way to frame it, the discussion in the end, but also to help us to think as we go forwards. Thank you very, very much to all the speakers. This has been a really, really rich discussion. And also to all our participants who joined us today. Please join us next week as we take forward the discussion in our fourth and final episode in the webinar series on where we'll be looking further at these questions relating to what does adequate human rights due diligence for climate change look like in practice. And many of the themes that were obviously discussed today will be taken up again in that seminar and into the future. So thank you again very much for joining us today, and we look forward to seeing you hopefully next week. Thank you.